Mike, why don't you talk about what a special needs trust is and how it fits into an overall estate plan?
As a general matter, a special needs trust is a necessity. If you have a child who may not be able to work, the test of disability in this context, by the way, for government benefits is not the particular diagnosis. It's whether or not the individual can get a job and keep a job. Can they make a living? And if not, they are disabled in the context of government benefits. And many of them have asset and even income criteria that have to be satisfied. Bottom line is when you set up this irrevocable trust for the benefit of your child, any amount of money can be in that trust. None of it counts. None of it interferes with eligibility for government benefits. They're not one size fits all. Some people have need to be in an institution, some at home. So it's fine-tuned to make sure that it fits properly. But again, it's the key element to hold assets for your child, to provide a lifelong safety net, to make sure that in addition to any government benefits, there are also resources in this trust to make sure that your kid is taken care of for life. And then the trust ultimately says what happens with those assets when you pass.
Right. And very importantly, you're naming the person or the entity who will oversee that trust for them. So you're making sure that a trusted third party is always overseeing this money for the benefit of your loved one as well. Mike, why don't we talk about the different types of special needs trust, first party versus third party? What are these terms? How are they relevant?
Of course, these are nicely described, summarized in our book as well. The typical trust that is created for a child with a disability or for a sibling, by the way, or sometimes even for a parent, is where the parent creates the trust for the benefit of the child. And that's what's called a third party trust. The idea is some third party, somebody other than the child himself, is putting the money into that trust and creating it. So again, typical trust, parent creates it for the child is the beneficiary. Key point, upon the death of the child, upon the passing of the beneficiary, the parents decide what happens with money remaining in that trust. Does it go to other family members? Does it go to a charity? It's up to the parents. The state doesn't touch it. There's the difference with the first party. The first party special needs trust is where it is the disabled individual's money that goes into the trust. So if somebody's hurt in an accident and they're newly disabled, they can create a first party special needs trust. They don't need anybody else to do it. They can shift all of their money into that trust and they immediately qualify for government benefits. That's a transfer that doesn't interfere with eligibility. The key difference here, again, is that with the first party trust, there must be a provision saying upon the death of the beneficiary, before anybody else gets any part of that money, there must be reimbursement to the state of California for Medi-Cal benefits and perhaps other benefits that have been paid. So again, that's the crucial difference. 9 out of 10 trusts are third party. But there's a significant number of first-party trusts out there as well, which we do routinely.
The question we get a lot is, if I create a special needs trust for my loved one, can the state go after it after they pass away? And it depends on the type of trust. If you create it for them and it's your money that goes into it, the state cannot touch it. If the money goes to your child first and they have to create their own special needs trust, then the state can go after that money when they pass away. So that's the third party versus first party necessity of planning ahead when you can. It's really important. It's not just a special needs trust. It needs to be part of a comprehensive plan.
When we're setting up the special needs trust for the child, for the beneficiary, and 9 times out of 10, it's the child. But again, it could be other family members. It could be a sibling. The parents must also create their own living trust because they have to direct money in their estate to the special needs trust. It doesn't happen automatically. So the trust needs to be coordinated with the special needs planning, powers of attorney, and the advance directives, both for the parents and ideally for the child, by the way. Many individuals who are disabled and can't work have a sufficient level of capacity to sign their own power of attorney and to sign their own advance directive. And often, by the way, that's a key to avoiding the need for a conservatorship, where you have to go to court and a judge appoints somebody to manage affairs. So all of these pieces of the puzzle need to be coordinated. They need to fit. They need to be done for both generations, ideally. But again, the point is to address the special needs challenges in all of these documents, just to be sure that your child is going to be taken care of. So again, very important point. You have your irrevocable trust. We all have that, or we should. The special needs trust is created now. It sits there empty, waiting for you to fund it while you're living, or more typically, it's funded upon your passing.
Very simple summary of this. Mom and dad have their own separate living trust that needs to be up to date. It needs to say that, if, let's say you have a daughter, Sarah, who has a disability, you do not leave anything to Sarah. You create the special needs trust for Sarah separately ahead of time. And you say, upon my passing, I'm not leaving money to Sarah, I'm leaving it to the special needs trust. And you need to set this up ahead of time. And we only do this where we create the special needs trust as a separate document, a separate entity. It should not be embedded in your living trust. There are many reasons for that. One of which is you may want to put money in it while you're still living. And if it's not a separate entity, you can't put any money in the special needs trust until you're gone.
And by the way, as we did for some clients just yesterday, it was a grandparent who wanted to leave some money for the benefit of their disabled grandchild. Yep. They were going to leave the money directly to her, which would have been a small scale disaster. They learned that we prepared a special needs trust. The parents did. So the grandparents, they were leaving about $10,000 to the special needs trust. It had to be a freestanding separate entity, couldn't be embedded, waiting to be created upon the parent's death. So again, how 3 generations can fit together.
Yeah, absolutely. So we get the question a lot too of, well, if I put me a special needs trust, isn't that really limited in what it can pay for? Like, I don't want to limit it only to things that government benefits don't cover, because government benefits barely cover anything these days. There's not enough. So what can a special needs trust pay for when it comes to your child after you're gone?
The way you think about the use of funds in a special needs trust is that they are there for the quality of life of your child. Whether it's medical care or enjoyment or housing, the money can all be used. There are some limits in limited circumstances, and most of those limits are avoidable and they don't create a problem. So the real bottom line, and you see a list here of some of the more obvious uses of money in a special needs trust, it's virtually anything that's needed for the quality of life for the beneficiary. And there's great flexibility to the trustee, the person who's managing these funds, to make sure that everything is handled properly, and again, that the child is well taken care of.
I know what you guys are probably thinking. You're thinking, well, food and shelter, all that stuff is nice, but can special needs trusts pay for Britney Spears concert tickets? Yes, they can. Okay, now Britney Spears is obviously not quite as relevant now, no offense to Britney Spears, but this is actually based on a real case. There was a case where someone was challenged for using special needs trust funds to buy Britney Spears tickets for the beneficiary, and it was found that that was okay. So maybe today it's Taylor Swift or someone else, but there is an actual case about this. And I think this just points out that you can be very flexible with how special needs trust funds are used for the quality of your child or loved one's life after you're gone, or even while you're living, if there's money in it. Let's set a meeting. Let's review your plan. If you haven't, we invite you to join our client community. Reach out to us at gilfix.com or 650-493-8070. Easy to find us. Set that planning meeting. Let's review it. The stakes are too high to leave this to chance. If you haven't subscribed to our Gilfix Law YouTube channel, subscribe to it. Easy to find us. We're up to about 3,000 subscribers at the time of this. Hopefully by the time you're watching this on YouTube, it'll be even more. But if you are watching this on YouTube, like, comment, share, leave a question or comment for us if you have any questions. Talk to us if you're not sure. Just talk to us. A little bit of planning can have massive impacts on the future.